Bruno Canuto and State Solicitor Joseph Roman D. de la Cuesta. Other lawyers of the OSG are in the gallery to provide assistance whenever necessary. Thank you.
Appearing as Amici Correa this afternoon are Justice Adolfo S. Ascuna, retired, Attorney Elizabeth H. Aguiling Pangalanan, Attorney Milencio S. Santa Maria Jr., Attorney Maria Lisa A. Lopez Rosario, Attorney MacGyver Doria in lieu of Attorney Maria Carolina Ligarda, and Attorney Eliezer Ambatali representing Dr. Claire Dennis S. Mapa. Thank you. I will proceed with the interpellation of Justice Samuel Garland. Justice Sam.
Thank you, Chief. An awesome afternoon. Okay. At the outset, the court notes that this case was initially presented as a pure question of law, specifically the scope of Article 26, Paragraph 2 of the Family Code. However, in light of petitioner's compliance, the court is now confronted with a materially different situation. The case now raises not only doctrinal issues, but also the validity of a second marriage contracted while a prior marriage subsisted, the limits of Article 26(2), and whether there remains a justiciable controversy at all. Now, before proceeding with the legal issues, let me give an overview of the timeline and relevant facts. Petitioner and respondent were married on March 14, 2000 in Quezon, were Filipino citizens. In 2006, petitioner filed a petition for declaration of nullity of marriage before the RTC. This petition was denied for lack of merit. Following this denial, petitioner emigrated to the United States. On October 18, 2010, petitioner obtained a divorce decree from a court in the United States. At that time, it is undisputed that petitioner remained a Filipino citizen and respondent likewise remained a Filipino citizen. Shortly thereafter, on November 8, 2010, petitioner contracted a second marriage. At that time, petitioner's first marriage remained valid under Philippine law, and the second wife was likewise still a Filipino citizen. 2 days later, or on November 10, 2010, the second wife became a naturalized Filipino citizen. Several years later, in 2019, petitioner himself became a naturalized citizen of the United States. In 2020, petitioner reacquired Philippine citizenship pursuant to Republic Act No. 9225. Following his reacquisition of Philippine citizenship, petitioner filed the present petition for recognition of foreign divorce under Article 26(2) of the Family Code. Significantly, in his compliance submitted after the first oral arguments, petitioner made the following admissions. First, that he remarried before acquiring foreign citizenship. Second, that at the time of his second marriage, his first marriage remained valid under Philippine law. And third, that the purpose of seeking recognition is to acquire property and to hold a religious wedding ceremony in the Philippines for his second marriage. In sum, this is the sequence of what petitioner wants or prays: failed nullity, foreign divorce, remarriage, then naturalization, then recognition. Given this overview, I have framed my questions in 4 main categories: justiciability and purpose of the petition, to determine whether the case should proceed at all on the 2, on the validity of the second marriage, 3, the nationality principle, and 4, the equity versus abuse of process, to examine whether equity is properly invoked. With that, may I call on the counsel for the petitioner to take the rostrum. Now, Mr. Counsel, on the justiciability and purpose of the petition, if the court denies the petition, what concrete legal injury will petitioner suffer?
Your Honor, should the Honorable Court decided to deny this petition, in view of the fact that he already reacquired dual citizenship by virtue of Republic Act number 9225, the petitioner will somehow be regarded as a lesser Filipino. Why? This is because, Your Honor, under Republic Act 9225 was actually enacted in order to fully restore the right of Filipino, natural-born Filipino citizen, to regain all their political and civil political rights without discrimination or diminution of rights. For that reason, Your Honor, it will in effect render the petitioner less Filipino. Admittedly, on the political aspect, he able to restore his citizenship, or rather full Filipino citizenship, given that he can vote, he can even run for public office. However, it is also imperative that recognition is not just about recognition, or rather restoration of political rights. It does also include restoration of the civil rights, which necessarily include the right to seek clarification on matters affecting his civil status. Because if the respondent will not be given or accorded the right to have his petition, foreign divorce recognized, he will be in fact in the position which Manalo, Article 26, Paragraph 2, tried to avoid, which is being bound or having a completed marital status. He will be regarded as married under the American law, and then he is unmarried, or shall we say still married to the Philippine spouse under the Philippine law. That is the dilemma, Your Honor, that the petitioner have to deal with in case this petition would be denied.
So am I correct to say that there is a conflict between the Philippine law and the American law with regard to this matter?
Actually, Your Honor, there's technically no conflict between the dual citizenship of the petitioner, because technically, when the petitioner subsequently become a foreign national, which is in this particular case an American national, his citizenship or the personal law that governs his personal status has shifted from the local or from the Philippine law to that of American. Technically, what the Honorable Court, what the petitioner actually seeking in this court is just modesty aside, is the recognition. And recognition actually does not involve questioning or dealing into the validity of the foreign divorce, which was secured by the petitioner as an American. And it boils down to the very nature of a recognition proceedings, Your Honor.
Yes, counsel, but it is not only about recognition, because there are legal consequences when the court recognized the divorce made by the petitioner in a foreign country. Am I correct?
Yes, Your Honor. Yes, Your Honor.
Okay. Now, is it correct that petitioner's primary intention now is to hold a religious ceremony in the Philippines? That was in your compliance. That was you stated.
Yes, Your Honor, I admit on that. But it's actually more of the, the brief statement of summary of what intimated to be by the petitioner. Of course, petitioner being non-lawyers does not understand or fully understand the complexity and of the consequences, Your Honor, in case this petition for recognition will be granted or denied.
Now, has petitioner made any inquiries with a Catholic priest regarding the possibility of solemnizing the second marriage?
Your Honor, I understand that the marriage that they're planning to do in the Philippines, between the petitioner and the second wife, is not a Catholic.
Okay.
But I think they already adopted by passing that it gonna be a Christian wedding.
A Christian, you refer
That's
to
what they're planning.
let's
Yes,
say, a born-again Christian ceremony. Okay. Why does petitioner still insist on having his divorce judicially recognized when essentially this is not needed for purposes of an intimate religious ceremony that would have no legal effect anyway?
Your Honor, it is the petitioner's understanding whether it is legitimate or not, or acceptable or not, is that should they opted to, or the petitioner in the second wife decided to file, or rather to celebrate, have their marriage celebrated in the Philippines, they would run the risk of being prosecuted for bigamy, Your Honor. This is because, again, in view of the nature of the recognition proceedings, that it is a judicial, that unless a judicial recognition was accorded or extended by the court, it is without effect in the Philippines, Your Honor.
Now, on the validity of the second marriage, is petitioner now asking the court to retroactively validate the second marriage by recognizing the divorce?
I have to be candid about that, Your Honor. We never considered that particular relief, but somehow, should it be recognized, Your Honor, this particular the Honorable Court opted to extend recognition to the first marriage between the petitioner. It necessarily carries with it the legitimacy or conferring legitimacy to the second marriage.
Okay. At the time of the second marriage, did petitioner believe that he was already free to remarry under Philippine law?
No, Your Honor, because he is aware that being a Filipino, divorce is not recognized among Filipinos because of the principle of nationality principle. And I do believe that he is very much aware, and that actually the reason why he opted instead of just marrying or celebrating another marriage outside the country, in view of their foreign nationality, which they can do, they still opted to file this recognition purposely to have the first marriage recognized, Your Honor.
Now, what advice did, if any, did you give to your client once you discovered from the facts stated in the compliance that he married his second wife while both parties were still Filipinos?
Actually, Your Honor, when I found out that the petitioner got contracted second marriage after divorcing the divorcing respondent in this case, Your Honor, to be honest, I was surprised because they never told me, because they just told me that the second wife is already American. But I only found out later that the second wife is actually still remains a Filipino national when they contracted the second marriage, and that the second wife became foreign national or American citizen only a week or less than 20 days after the celebration of the second marriage, Your Honor.
Okay. Now, on the nationality principle, What is petitioner's position as to the reckoning point of citizenship for purposes of Article 26, Paragraph 2, at the time of divorce or at the time of recognition?
With due respect, Your Honor, the petitioner maintains that the time to reckon for purposes of recognition is not necessarily the time of the celebration, or rather the nationality of the parties at the time of the divorce, but at the time the petition was sought, Your Honor. If I may, Your Honor, may be allowed to expand on my answer a bit.
Yes, please.
Okay. Thank you, Your Honor. This is because when the honorable court, rather the local court exercises what the local courts as local court recognizes or acknowledges in petition for recognition is not actually not validity of the foreign judgment. What actually recognized is the effect of the foreign divorce on the civil status of the parties. And recognition actually happened at the time the petitioner filed a petition for recognition, and not necessarily at the time of the divorce, Your Honor. That's why, because it is the time when the petitioner invoked the jurisdiction of the local courts, Your Honor. That's why, Your Honor.
On what legal basis does petitioner argue that subsequent naturalization alters the legal consequences of acts performed while he was still Filipino?
The legal basis is the objective of Republic Act number 9225. Actually, which provides that, if I may refer to my notes, Your Honor, to be precise, is to uphold the principle that the natural-born Filipino citizen is permanent, and to encourage Filipinos who have become citizens of another country to fully establish their political and civil ties to the Philippines without discrimination or diminished rights, Your Honor. And that is basically the fundamental reason why the subsequent acquisition of the petitioner of Philippine citizenship does not in any way affected or does not legally affected the divorce he obtained while he's still an American citizen, Your Honor.
So that will also be the legal consequences now that petitioner has reacquired his Filipino citizenship.
Yes, Your Honor. Add to that, Your Honor, reacquisition of dual or rather Filipino citizenship is imperative so that the petitioner will be able to have a legal standing in court to file this petition for recognition, Your Honor.
Okay. Now, on equity versus abuse of process, should equity operate in favor of a party who, after failing to obtain relief under Philippine laws, sought divorce abroad and now seeks recognition here?
Yes, Your Honor. I honestly believe that the evident intent Article 26, Paragraph 2 is more important if we taken together in its totality, which is the avoidance of existence of limp marriage, is actually imperative and does not go against the principles of equity, Your Honor. And in harmony with the legislative intent, I honestly believe that the petitioner can file or institute or maintain this petition, Your Honor.
Thank you, Counsel.
Thank you, Your Honor.
Now, may I ask the Solicitor General, Madam Solicitor?
Good afternoon, Your Honor.
Good afternoon. For the Solicitor General, I will focus my questions on the case-specific consequences of the positions advanced. Okay. And I have just few questions, Madam Solicitor General. Okay. If dual citizens are validly divorced in a foreign state but still married under Philippine law, how will this affect their property relations with respect to their properties in the Philippines?
the nationality principle will still apply to the Filipino spouses.
Nationality principle, what do you mean by that, Madam
Your
Solicitor?
Honor, may I clarify that you are referring to spouses who are
Yes. Dual citizens, referring to both Filipino and both Americans,
if the
are validly divorced in a foreign country, but still married under Philippine law.
then the properties which are in the Philippines will be governed by Philippine law, Your Honor.
Philippine laws, okay. For purposes of marriage or marital rights, when does the state consider a dual citizen as Filipino, and when does the state consider them as a foreigner? Are there any specific doctrines regarding this?
Your Honor, I would say that there is a lot of leeway for interpretation under the implementation of RA 9225, simply because even if we read the deliberations on the law, the focus was more on the political rights, political obligations, and there was a mention and thereby also not pursuing the point as to the applicability of the nationality principle. So because there is a nationality principle for personal rights and obligations, it was kind of dismissed that then it is the civil code that will be applicable, Your Honor. So there is a lot of leeway for interpretation.
Okay, thank you. Now, assuming that the petitioner's divorce decree is defective and cannot be recognized in the Philippines because it was acquired before he was naturalized, can the petitioner and those similarly situated obtain another foreign divorce after their naturalization? And can this second divorce decree now be recognized in the Philippines?
I would say, Your Honor, that that is possible to obtain another foreign divorce. I recognize that obtaining another divorce from the U.S. will not prosper, but that is a possibility to go to another jurisdiction and obtain a divorce.
Now, if the divorce decree was obtained when they were already American citizens or a citizen of a foreign country, can the court now recognize the decree of divorce?
They have been naturalized, Your Honor, so Republic versus Orbecido will apply.
It will not apply. Okay. Should the court consider whether public policy today must be understood in light of globalization, migration of Filipino workers, and increasing instances of transnational marriages?
I would say, Your Honor, that public policy is not static. And the sources of how we determine what public policy is are, number one, the Constitution, because the provisions in the Constitution and the Declaration of Policies itself was a decision made by the framers of our Constitution, what is included and what is excluded. Apart from the constitutional provisions, the statutes are also a source of guidance for what is public policy. And third, the jurisprudence, as enunciated by this honorable court, would also be a source of guidance on how the policies enunciated by the Constitution and our statutes are applied to specific cases. It is because generally, when our legislature, for example, pass laws, they usually would not be able to anticipate or encompass all the nitty-gritty or specific cases. And that's why the Supreme Court is in a unique position when you are confronted with specific cases, and therefore the Supreme Court tries to apply the policies that are given by the Constitution and statutes. So it is not static, it is changing, but it doesn't have to be on a case-to-case basis that we determine whether is it public policy today, and in the next case, is it not public policy?
Yes, because public policy has evolved from allowing limited divorce under ACA 2710, then prohibiting it, and later to partially recognizing through foreign divorce under Article 26.2. Now, does this trajectory suggest that public policy on marriage is dynamic, as you have mentioned earlier, rather than absolute? Can you give us some limits of judicial interpretation in this regard?
I would agree, Your Honor, that it is not static. So, in fact, the Congress and Senate, or the legislature, has a lot of pending bills on divorce, starting from, I think, the 14th Congress. And every year thereafter, there is a filed bill on divorce, which shows us that maybe the constituents are going to their representatives and asking for a law to definitively define what is the Philippines ready now in light of modern times. However, as long as Congress has not yet passed a law on divorce, then we are confronted with the provisions under the Constitution, under the Family Code, and with that narrow exception that is provided by Article 26, Paragraph 2, which is really intended to be that, a narrow exception, and with specific requirements when it can be invoked, which, Your Honor, if I may say, is not present in this case.
Okay. Now, while the court does not decide based on numbers, is there any empirical basis to suggest that cases of Filipinos obtaining foreign divorces prior to naturalization and later seeking recognition are sufficiently widespread to warrant doctrinal adjustments?
I have come across, Your Honor, the data that were provided, and there were years that there were a lot of petitions for recognition of foreign divorce. We are not aware if that is a faithful representation of the actual numbers, but based also on the testimony of the some amici, so it seems that there is a considerable number that needs immediate attention by our Congress to address the issues that are affecting our our other Filipino members.
Now, as a Solicitor General, what is the position of the OSG with regard to this foreign divorce?
With regard to this case, Your Honor, it is our position that Article 26, Paragraph 2 does not apply because both spouses were Filipinos at the time of divorce. And therefore, as you have mentioned, Your Honor, there are so many factors that lead to the dismissal of this petition because it involves factual issues. It went straight to the Supreme Court, violating the hierarchy of courts. Number 3, I would also respectfully submit that he who comes to the Court of Equity must come in clean hands. And in this case, it is our submission that the petitioner does not have clean hands because of the fact that you have included in your introduction. It might be important to highlight that the petitioner has already filed a petition to declare their marriage null and void, but the court has already denied it. And after that, went to the US and filed for divorce. So on many counts, Your Honor, it is our submission that this petition should be dismissed.
Now if ask you the same question, not as a Solicitor General, but as Madam Darlene Berberabe, will your position be still the same?
Your Honor, my position will still be the same, and I would join this honorable court and the amici in giving all the data, all the arguments to our Congress in order to consider and pass a law that will address the many issues that are confronting the Filipinos because of the present state of our law.
Thank you, Madam Solicitor General,
Thank you, Your
for
Honor.
that candid answer. Now, I have some questions also to the amici. Okay. I will begin a few questions for Professor Pangalangan.
Good afternoon, Your Honors.
Good afternoon, Professor. Okay. Now, Professor, does any conflicts of law principle allow retroactive validation of marital status?
Retroactive validation of marital status? Your Honor, yes. In private international law, in deciding what the applicable law is, the court may acquire, or rather may apply, an approach called the most significant relationship approach, which will look at the connecting factors between the parties and the forum. And if it sees that, for instance, as in this case, after the divorce, this Mr. Baluyot has, as was revealed to us during the last oral arguments, remained resident of the US and has in fact remarried, then applying the most significant relationship approach, the center of his life is now or has been in the United States, and therefore that could justify the recognition of the foreign divorce, Your Honor.
So does petitioner's voluntary return to Philippine jurisdiction negate reliance on foreign law?
Your Honor, may I be clarified? So the return to Philippine jurisdiction is in the sense of his reacquiring
Yes.
Philippine citizenship. Well, Your Honor, that's a difficult question. But since he, at that point, becomes a dual citizen, then he is governed by both the U.S.
Yes,
law and the Philippine law. And therefore, even if we apply the nationality principle, Your Honor, I believe that this is a situation of conflicting nationalities. And in this case, I look at the possibility of applying the doctrine in the Nottebohm case, which is a public international law case, but which laid down the doctrine of effective nationality, Your Honor.
Okay. Now, are dual citizens more prone to experiencing limping marriages? That is, marriages recognized as dissolved in one jurisdiction, but subsisting in another, particularly after acquiring or reacquiring a second citizenship?
Yes, Your Honor. In fact, that is one of the results of recognizing the divorce according to American law, but the divorce is not recognized according to Philippine law, and the parties are still deemed to be married to each other. So, Your Honor, yes, this is a limping marriage, and dual citizens, and even, I think, Filipinos, even if they're both Filipinos, but where the center of their lives, let's say their domicile or their habitual residence, has been in another country where this divorce is recognized, then they will be subject to limping marriages, Your Honor.
Okay. From a conflict of laws perspective, does the phenomenon of limping marriages justify a more flexible approach to the recognition of foreign divorce decrees, or does instead underscore the need for clearer statutory limits?
Thank you for the question, Your Honor. I believe, Your Honor, that the phenomenon of limping marriages can be resolved, can be addressed by the court, although legislation would be one way of resolving this. It can also be subject to judicial reinterpretation of the existing laws, Your Honor. And that it's important that this be resolved, Your Honor, because as it is, it undermines stability of civil statuses. And again, we've always, as a professor myself of persons and family relations for over 30 years, I've seen that we've changed, the laws have changed from the different statuses of children to now just legitimate or illegitimate. And the purpose of this is for stability of civil status. And yet in limping marriages, we have that in mid-air, and there is no determination of whether this person is married, divorced, or single. Likewise, it undermines the predictability of legal relations and the effect of those legal relations, Your Honor, such as in the case where there are properties left and one of the parties dies. So according to American law, the heir will be the second wife, but according to Philippine law, the heir will be the first wife. And also, it will undermine, limping marriages, undermine the recognition of family relations across borders. And for me, Your Honor, this is a serious problem because of the realities in the Philippines of transnational families.
Now, in situations involving dual citizens, should the court prioritize uniformity of marital status across jurisdictions or uphold domestic legal consistency even at the cost of limping marriages?
Your Honor, as a professor of private international law, I believe that it is important for the Philippines, through the Honorable Supreme Court, to be able to resolve this problem. And I don't think we are sacrificing Philippine law or the nationality principle. I believe that we are not putting in jeopardy consistency. In fact, what I believe, Your Honor, is that by recognizing the foreign divorce, this is actually in keeping with what I see as the functional flexibility in court decisions, where the court looks at the lived realities of the parties who come to court, the litigants, and it recognizes that people whose lives have been centered abroad, their economic, social lives, for instance, their family relations are all abroad. And this, I think, is the reason behind the more flexible, I would say, interpretation that the court has given Article 26, Paragraph 2 of the Family Code.
So, do I get it from you, Madam Professor, that it is about time that we have to recognize the divorce here in the Philippines?
Well, Your Honor, in the first place, if I may, Your Honor, I think that in the first place, we do recognize it from the fact that we have the Code of Muslim Personal Laws, and we have also Article 26, so we do recognize foreign divorces. So I would say that the Philippines, as of now, recognizes divorces under special or specific circumstances, Your Honor. It's not a hard and fast rule anymore. And that divorce or the passage or the recognition of divorce is not necessarily a violation of public policy. And Your Honor, in the recent trends in private international law is that it's not just public policy, but the requirement by the Hague Conventions, for instance, is that it is the foreign judgment must be contrary to the manifest, so manifestly incompatible rather with the public policy of the forum. So not just a violation or contravenes public policy, but manifestly incompatible with the forum's law. And in the Philippines, there is no manifest incompatibility because we have no law, Your Honor, that says divorce shall not be allowed. We just have no law on divorce. So even if the court recognizes foreign divorce, it will not be a violation of public policy. So I believe that it is time that such be recognized, Your Honor.
Thank you, Professor.
Thank you, Your Honor.
Now, may I turn on to Professor Santamaria and Attorney Doria for Professor Ligarda. The court would appreciate your guidance on the doctrinal and policy aspects of divorce under Philippine law.
Your Honor, at the outset, Your Honor, I would like to just say something about limping marriages.
Okay.
This was a problem in Europe in the late 19th century,
Okay.
and then they were able to fix it. It's still a problem in the Philippines.
It's still a
So
problem
we
here.
are living the problems
Okay.
of a society that no longer exists.
Okay.
I just want to say that, Your Honor. Limping marriages, Your Honor, can be cured, not by Article 26(2), but precisely the petition for recognition of foreign judgment. We must remember, Your Honor, that Rule 39, Section 48 has been constitutionalized by Mijares versus Raniada. In that case, Your Honor, the Supreme Court said that this petition is the prevalence in the world of the use of this petition and the opinio juris sive necessitatis has already been attained. It is customary international law. And therefore, if it's customary international law, then by the doctrine of incorporation in our Constitution, it is part of the law of the land. And so that this rule of court has been elevated to a constitutional right, if at all, or at the very least, a statutory right. And so that therefore, Your Honor, if we must now look at Rule 39, Section 48, not as a fortress, Your Honor, keeping out changes, but a bridge connecting the civil status of a person with his lived reality. Because as it stands now, Your Honor, our public policy caters to a split personality which will affect the health and mind of individual. He is married in he is not married in the United States. He is married in the Philippines. It invites, Your Honor, bigamy, adultery, concubinage. So the more we put a negative aspect or the safety valve as a point of refusal, then that will not be positive to our implementation of our law, Your Honor. So that is precisely my point, Your Honor. 26(2) might be irrelevant in this case. It is Rule 39, Section 48, because it is that rule which will connect us to the whole world, Your Honor, to the whole world, which will fix everything, Your Honor, which will fix everything, Your Honor. So that's the point, Your Honor. So if we look at that perspective, Your Honor, then we would have solved the problem, because public policy is created by the legislature but is identified by the Supreme Court. You do not create public policy. You identify it through the Constitution, through law, through our lived experiences, through the shifting social norms, through development in psychology, medicine, and enlightened jurisprudence and law. Your Honor, public policy is the collective conscience of a community. Your Honor, if public policy, Your Honor, is frozen in the era of its first articulation and still implemented today, then we are living in the ghost of a society that no longer exists. If we are to look at society now, public policy today, we cannot go back to 1939. We cannot go back to 1964, the ruling in Chavez. We must see it at the present time. That is why, Your Honor, the Supreme Court is an agent of evolution. This is a pivotal moment now in our history. As 1939, 1964, outdated public policy, Your Honor, from a policy of indissolubility at all cost to redemption and human dignity as provided in our Constitution. If that is the perspective on how we look at Rule 39, Section 48, we would have solved the problem, Your Honor. We would not be living in a policy with a split persona, with a split screen, Your Honor. It cannot be that way. The Rule 48, Rule 39, Section 48, is the procedural vehicle to provide a singular status to a Filipino, especially in dual citizenship. Because a double status, Your Honor, will really create problems. Let us not go into it is now the opportune time, Your Honor, to say through judicial identification of a public policy. And the Supreme Court said, in the absence of any provision in the Constitution or in statutory law, the court can look into what is public policy by deciding whether the situation or the transaction is injurious to the people. So that is the point, Your Honor. I think everything will be decided here. If at the point of divorce, both are Filipinos, we get rid of that, and we still say today that we will not recognize it, then, Your Honor, we are living in the 19th century. And one thing more, Your Honor, this whole point on circumvention of the law, this whole point on backdoor, I think sometimes it's so irritating, Your Honor, to assume that a Filipino going abroad just trying to comply with Rule 39, Section 48 is a malicious Filipino. The law, the rules are there. The rules are there. And Rule 39, Section 48, Your Honor, admits of one fact. The journey starts abroad. It ends here, Your Honor. And the blow that will terminate the marriage, Your Honor, is not Rule 39, Section 48, Your Honor. It was an event before a judgment. And the judgment is rendered, and we look at it as a fact. We do not look at the merits of the case, and that's why in Republic versus Nya, we even recognize this court. A termination by letter, just registered in Japan. Your Honor, that is revolutionary and that is good. Your Honor, that is good. And so therefore, Your Honor, the blow was before. We only recognize a fact, and that fact is the judgment. And it is a presumptive evidence of a right. And the right is being single. And to marry because of you are single is not even contrary to public policy. That is the point, Your Honor. We might be deviating so much on 26.2. It is not 26.2. It is Rule 39, Section 48, Your Honor.
Thank you, Dean, for that enlightenment. Now, may I ask Attorney Doria, in lieu of Professor Legarda?
Awesome afternoon, Your Honors. Before I answer your question on public policy, may I just be briefly permitted to comment on the status of the second marriage? As indicated, because of the facts, because of the compliance sent
No,
by...
I have just two specific questions to you, Attorney Doria. Okay. Under Act number 2710, divorce was permitted on limited grounds. What does this indicate about the public policy of the state towards marriage and divorce at that time?
Your Honor, we submit again and reiterate Professor Legarda's position that calling or stating that there is a broad manifest public policy against divorce might be incorrect, given that one, it is historically ignorant. It fails to take into account that Act 272 did permit absolute divorce for two grounds. That would be adultery and concubinage. During the Japanese occupation, the Japanese government here in Manila expanded the grounds from 2 to 11 grounds. And also, if the court remembers the case of Benedicto versus De La Rama, the Código Civil of 1889 actually did include provisions on absolute divorce for two grounds, except that the court noted in Benedicto versus De La Rama that the provisions of the absolute divorce were withheld by the Spanish crown on its colonies through a issuance from the official Gaceta de Manila, which meant that at the time the court decided in Benedicto versus De La Rama, absolute divorce was not granted because what was used by the court was the Siete Partidas, recalling the Council of Trent. A second point, Your Honor, is that under the Code of Muslim Personal Laws, absolute divorce is granted. So if we fixate on the notion that there is a broad, unqualified, and absolute public policy against divorce, then we would be culturally insensitive because our statutes actually carry provisions on absolute divorce, albeit applicable only to Muslim marriages.
Okay. Now, when divorce was later removed under the Civil Code, was there an express legislative declaration that divorce is per se contrary to public policy, or was this more a matter of policy shift?
No, there was no categorical declaration, Your Honor, that there was a public policy against divorce. Simply that, first, the Bukobu Commission still retained the provisions on legal separation, what is we all know as relative divorce. What it did suppress were the provisions of the Código Civil of 1889 on absolute divorce, which means that, as intimated by Professor Pangalangan earlier, there is a difference between a prohibitive language versus the absence of a mechanism. And we humbly submit that the absence of the mechanism of absolute divorce here in this jurisdiction does not necessarily mean that there is a broad public policy against absolute divorce, Your Honor.
Thank you, Attorney Doria. Thank you. Now, may I turn to Professor Rosario, Lopez Rosario, for her guidance on relevant canon law considerations.
Good afternoon, Your Honors.
Good afternoon. Now, Professor Lopez Rosario, which specific provision of the Code of Canon Law prohibits the solemnization of a second marriage when a prior marriage subsists, that's notwithstanding the non-recognition of a civil divorce decree? And how does this relate to the principle of the indissolubility of marriage under Canon 1141?
Your Honor, under canon law, marriage is a sacrament. And considering that it is a sacrament, it is something that is inviolable, indissoluble. And therefore, contracting a second marriage is against the nature of the sacrament of marriage.
So if a ceremony is conducted would it have any canonical validity, or would it merely be a non-sacramental or symbolic act?
It depends who celebrated the marriage, because under canon law, only the clergy, the bishop, are given the authority. There's a reason why a civil marriage is not recognized under canon law.
It is not recognized?
It is not recognized under canon law.
A civil marriage?
A civil marriage.
So what happened to my marriage? So it's null and void? No.
You may want to have a religious ratification of your marriage, Your Honor. I'll work on it.
No, I'm just... now, if would such a ceremony produce any civil consequences if conducted by licensed solemnizing officer?
Canon law, there is such a thing as canonization of civil law. In other words, canon law respects, for example, what are the formal and essential elements for a valid marriage. But other than that, of course, what canon law gives priority is the sacramentality of marriage. As a matter of fact, I handled one situation, Your Honor, if I may be allowed. There was one party who obtained a decree of divorce abroad. Okay? And my recommendation before the marriage in the Philippines, the second marriage here in the Philippines, will be celebrated, there is a need to require for judicial recognition of that decree of divorce. However, most of the members of the family are already in the Philippines. They came all over from other countries. And the marriage is already set or scheduled, I think 2 or 3 days after I was asked about my opinion. So I insisted that there should be a judicial recognition first before the sacrament of marriage should be celebrated. But then, since all the members of the family are already present, the clergy decided to celebrate it. So I asked the priest, after getting the judicial recognition internally, it is advisable that there be another celebration. And you know the comment of the clergy. In canon law, once it is celebrated, since it is a marriage, a sacrament, it cannot anymore be celebrated. And that's the reason why I told the priest, canonically, I respect that. But of course, I'm trying to foresee what will be the problem in the future if ever the marriage will not work. So it will be easy for the other party to immediately file a petition for declaration of nullity because of the non-recognition of the decree of divorce of the other party.
When we speak of canon law, we're referring to the Roman Catholic Church.
Yes, we have the Code of Canon Law of 1983, and up to now, it has not yet been amended. With the exception of the meeting given by the late Pope Francis, it has something to do with the declaration of nullity of marriage.
It does not apply to other religious denominations. Am I
It does not, Your Honor, although the Catholic Church recognizes ecumenism, meaning to say it can be a mixed marriage between a Catholic and a non-Catholic.
Okay.
It can be celebrated in a Catholic church.
So in this case, inasmuch as we learned earlier from the counsel for the petitioner, because I was of the impression then that they will be having their religious ceremony before the Roman Catholic Church. But it turned out that before a born again, or it's a Christian religious ceremony, so they are not covered.
They will not be covered by canon law, Your Honor.
Yes, okay. Thank you, Madam.
Thank
That
you,
will
sir.
be all, Chief.
Thank you, Justice Sam. Justice Roll, please proceed with your interpellation.
Okay.
Thank you, Mr. Chief Justice. Thank you, Chief. May I call on first the counsel for the petitioner?
Good afternoon, Your Honor.
Good afternoon. Counsel, can you just place on record your name again? I didn't hear you when you were entering your appearance earlier.
My name is Attorney Melvin De Castro Mane, Your Honor.
Okay. So before filing this petition for review on certiorari with the court, a petition for recognition of foreign decree of a divorce was filed, submitted already by you in your manifestations and in your affidavits submitted to the court before the RTC Gimba Levaisia. And may I know, were you the counsel of record in this particular case?
Yes, Your Honor. I'm also the
So you are familiar on what particular rule did you file this petition? Was it under Rule 108 or under Rule 39?
A petition, Article 26, Paragraph 4, Your Honor, recognition of foreign divorce, which is Article 26, Paragraph 2 of the Family Code, Your Honor.
Okay, so you resorted to Rule 39?
Yes, Your Honor.
Okay. Well, it is admitted in one of your affidavits that prior to this particular petition and even before your client migrated to the United States, he filed an annulment, a petition for annulment of marriage in 2006 before the RTC of Quezon City, and this was dismissed.
Yes, Your Honor.
Were you, again, the counsel of that particular case
No,
for
Your
the
Honor.
petitioner?
No, Your Honor.
Okay. So, would you agree that there is already a decision regarding this particular marriage involving the same parties before the RTC of Quezon City in 2006? You just wait for it. I would just like to come up with the premise. Thereafter, your client migrated to the United States, then filed as a Filipino a divorce, a petition for divorce before the Superior Court of California, the County of Los Angeles, and he was able to get that decree of divorce. Then after acquiring U.S. citizenship, he reacquired dual citizenship under RA 9225 and then filed a petition for recognition of judgment of a decision that was rendered more than 9 years ago. Do you confirm that?
Yes, Your Honor.
Don't you consider now this particular petition for recognition as a way of forum shopping? Because you already resorted to an annulment of marriage in 2006, and now you come to court asking for a recognition to dissolve the same marriage, which was the subject of that petition in 2006.
If I may, Your Honor.
Yes.
Your Honor. The petition maintained that does not constitute forum shopping or the principal application of res judicata, Your Honor. Primarily because of the nature of the action, petition for the declaration of nullity of marriage under Article 36, and the nature of this particular petition, which is actually a special proceeding, Your Honor. Both this particular petition actually involves a different cause of action, which is precisely to have their marriage recognized in the Philippines. While the first petition you file under 36 is basically to have it on the ground, or rather anchored on the ground of the psychological incapacity of the respondent, Your Honor. Although it involves the same topic, which is actually directed to the same marriage, but it constitutes a different course of action, Your Honor.
So
and
my question
the right involved, Your Honor. With due respect, Your Honor, this action is anchored on the fact that of his acquisition of a foreign judgment as an American citizen as well, Your Honor, as a dual citizen, to be exact, Your Honor.
But my question now is, did you, in filing this particular petition for recognition of foreign judgment or the decree of divorce, indicate in your certificate of verification and certificate of non-forum shopping the previous case that you filed?
No, Your Honor, I did not bother because...
Okay. That's fine with me. I'll be asking a lot of leading questions, so you don't have to answer, you don't have to explain anything, so that we can expedite my interpellation, also with respect to the others who are present here this afternoon. So it is basic that the Supreme Court is not a trier of facts. But during the first oral arguments, some facts have to be determined and established in order to address legal issues here. That's the reason why you were asked to submit some of the manifestations requested earlier during the first oral argument. So now, let me just try to establish the following. First, that on October 18, 2010, your client, Petitioner Melvin Baluyot, obtained a divorce decree already from the Superior Court of California, County of Los Angeles. And this was considered a default or uncontested divorce, is it not?
Yes, Your Honor.
So if you know, where was Maria Fe, the wife, residing at the time that the divorce decree was obtained by your client?
Is somewhere in Valenzuela City, Your Honor, actually where she still lives up to this date, Your Honor.
So in other words, she was, she was a resident of the Philippines, of course, a Filipino citizen at the time.
Yes, Your Honor. All
Okay.
throughout, Your Honor.
So there is no dispute as well that both Melvin and Maria Fe were Filipinos or are Filipinos when the divorce decree was obtained by petitioner. So this is very much known to the petitioner. Am I right?
Yes, Your Honor.
He's very much aware that when he filed that petition for divorce in the U.S., that he is a Filipino citizen.
Yes, Your Honor.
So there was this disclosed by him when he filed that decree of a divorce in the U.S.? Did he disclose that he is a Filipino citizen applying for divorce there
Yes,
in the
Your Honor.
U.S.?
Yes, Your Honor.
Okay. So it was established as well that it was only on February 20, 2019, or more than 8 years after the divorce decree was obtained, that your client, the petitioner, became an American citizen. So can you just tell us, based on perhaps your research, if any, if his acquisition of American citizenship has any retroactive effect with respect to his personal, civil, or political rights as an American?
Okay. As an American citizen, Your Honor, my answer will gonna be dealt on, Your Honor, on the issue of his ability to file this petition for reconstitution, Your Honor. This is actually based on the fact that the citizenship, although provided under, is only binding upon Filipino citizen, Your Honor. My petition is actually on the part that he subsequently became an American citizen, and that not necessarily constitute a validation of the foreign divorce, retroactive validation of the report, but a recognition of the fact of the legal effect of the foreign divorce he acquired as an American citizen.
Okay. So the answer is there is no retroactive effect?
No, Your
insofar
Honor.
as his civil or political rights are concerned?
No, Your Honor, that's my understanding.
Okay. So after the petitioner reacquired Filipino citizenship pursuant to, on July 30, 2020, or more than a year after becoming an American citizen, pursuant to RA 9225, he then filed this petition for recognition of foreign judgment. So why did it take him more than 10 years to file this petition? After obtaining the divorce in 2010, he only filed it after 10 years.
Yes, Your Honor. Actually, when I asked my client on that particular aspect, Your Honor, actually he could have applied for American citizenship as early as just 4 or 5 years after he became a green card holder or the permanent residence of America. But he opted to wait for another 4 years because he wants to acquire American citizenship on the basis of his personal qualification, Your Honor.
Okay. Okay. So he wanted to become an American citizen first before he can file the petition, or both to become an American and a dual citizen? Which is which?
Sorry, Your Honor.
Before filing this petition regarding the divorce decree that he was able to obtain, are you saying that he wanted to become an American citizen first or he wanted to become both an American citizen and a dual citizen under RA 9225 before filing this petition?
Yes, Your Honor. Actually, he first obtained his American citizenship, Your Honor.
Yes, I know that.
Yes,
But
Your Honor.
the decision to file the petition for recognition of foreign judgment,
Actually,
when did he really wanted to do that? When he became an American citizen, or when he became both an American citizen and as a dual Filipino pursuant to, dual citizen under RA 9225?
just after becoming an American citizen, Your Honor.
Okay. So is it correct to say that if he did not become an American citizen, he would not have filed this petition?
Yes, Your Honor.
And what would be the reason for not filing it, aside from not being an American citizen? Is it because of Article 26, Paragraph 2?
Because he's not that aware, at the time, Your Honor, he's not aware that it's possible that his marriage be recognized in the Philippines, Your Honor.
But would you agree with me that if he remained a Filipino citizen, he cannot avail of the provisions of Article 26.2?
Yes, Your Honor.
Okay. By the way, are you aware of the present citizenship of Maria Fe?
Maria Pe, she remains still Filipino, Your Honor, all throughout, Your Honor.
So she's still a Filipino citizen?
Yes, Your Honor.
Up to this time? Okay. So about Republic Act number 9225, which remains unamended actually since its passage in 2003. I hope you don't mind. Can I request so that at least you would be your memory will be refreshed regarding this particular law, if our technical people can show. That is intended not to be shown in fine print so that it will be difficult for you to read, counsel. I'm just kidding. But my question is this, regarding this particular law. Do you find anything there in RA 9225 which would entitle, by way of political and civil rights, being extended to a dual citizen? Is there anything there in that law which tells you that an American citizen who becomes a dual citizen, both American and Filipino, can actually have a decree of divorce obtained while he was still a Filipino to retroact and become ripe for recognition in the Philippines?
Yes, Your Honor. There's particular provision. It says that natural-born citizens of the Philippines, after the effectivity, become citizens of foreign country, shall retain the Philippine citizenship upon taking the aforesaid oath, Your Honor.
Yes, but so in other words, that would be the provision you think that will serve as basis for your client to be able to file a petition for recognition of judgment and to use the the decree of divorce that he obtained even while he was still a Filipino more than 10 years ago?
Yes, Your Honor.
Again, it was only after becoming an American citizen and then reacquiring his Filipino citizenship that your client filed this petition for recognition. And your main contention is that the foreign divorce obtained in the U.S. should be recognized in the Philippines, notwithstanding that he was still a Filipino at the time the divorce was decreed. Am I correct?
Yes, Your Honor.
So you're asking the court to be liberal in interpreting Article 26 of the Family Code. which applies to mixed marriages. Do you agree with that?
Yes, Your Honor, as adopted in Manalo, Your Honor.
So your claim that recognition of the foreign decree of divorce issued by the U.S., or particularly the Superior Court of California, does not create or legalize divorce in the Philippines and only pertains to that recognition of the divorce that he was able to obtain.
Yes, Your Honor.
But may I just ask, is this issue of divorce being recognized or legalized here in the Philippines also the focus or aim of your petition?
Yes, Your Honor. Yes, Your Honor.
So why did you say that? So you're saying that this petition before us right now actually is something that also presents directly or indirectly this issue of legalizing divorce in the Philippines? Is that what you're saying?
No, Your Honor. That is not, with due respect, Your
Yes.
Honor, that is
Okay.
that's not my point, Your Honor. Actually, as the nature of the Venetian petition for recognition implies, Your Honor, it is not the recognition or adaptation of foreign divorce in the Philippines. But what she is seeking is to have his foreign divorce obtained in the United States as American citizen to be recognized in Your Honor, so that there will be a consistency in his citizenship as well as civil status, or rather civil status in both in the Philippines and in the U.S.
Okay. So that is not the focus of your petition. Legalizing divorce here in the Philippines.
No, Your Honor.
Okay. So it is admitted that your client, petitioner Melvin Baluyot, already remarried and even has 2 children with his second wife. Am I not correct?
Yes, Your Honor.
So what is your evidence that your client and his second wife are actually married to each other?
They have a marriage contract, Your Honor, which is actually attached to my compliance. Your Honor.
Okay. So when the second marriage was contracted, the divorce decree obtained by your client was not yet recognized, is it not?
Yes, Your Honor.
So for all legal intents and purposes, and until the divorce decree is recognized here in the Philippines, he is still considered married to Maria Fe, is it not?
Yes, Your Honor.
So as a dual citizen, and legally speaking, your client, as a Filipino, can be considered as having violated Philippine criminal laws, like bigamy. Do you agree?
Your Honor, it is my understanding that bigamy is a criminal case, and the place of the commission of the crime is in the United States, given the marriage was celebrated abroad. Therefore, the possibility of prosecuted for bigamy is, with due respect,
He can?
outside the
He can?
jurisdictions in the
You're saying he
Philippines.
can?
He can.
He can.
He can. Yeah.
But he is a Filipino citizen.
Yes, Your Honor.
Okay. If at all, the recognition of the foreign decree of divorce obtained by your client, does it have any prospective or retroactive effect?
I'm sorry, Your Honor, I did not get
The
it.
recognition of foreign decree of divorce, is it prospective or it can be retroactive in effect?
I don't attribute any perspective or application because it actually it takes effect from the moment a foreign divorce was issued, Your Honor, because that is the exact time where and then exact time rather. I'm sorry, Your Honor. I stand to be corrected. As far as American law is concerned, that actually took effect when the moment of the foreign divorce was issued.
Okay. So,
As far as American law is concerned.
so the validity of the divorce decree is actually prospective.
Yes, Your Honor.
Okay. So, your client cannot be considered as being legally single under Philippine laws until that foreign divorce decree has been recognized by our courts here?
Yes, Your Honor, in view of the declaratory nature of recognition proceedings.
Okay.
Your Honor.
Thank you, counsel, for answering my questions.
Thank you very much as well.
May I just ask one of our amici, Justice Adolfo Ascuna, to the podium, please. My opportunity to ask some questions to the former Chancellor of the Philippine Judicial Academy.
Thank you, Your Honor.
And when I was a judge, you were you were still a sitting member of the court.
Yes, thank you.
So you favor, Justice Ascuna, the denial of the petition, is it not?
Actually, Your Honor, I was going over the submissions of my colleagues, and I realized that there is a way of recognizing this specific situation involved in this case as an exceptional and special situation covered by the intent of Article 126, Paragraph 2 of the Family Law. The rationale behind Article 126, Paragraph 2 is a situation of what we call in private international law as a factual situation with a foreign element. The foreign element here is not the place of marriage, but the citizenship of the parties. It is the requirement of this provision that one of the parties must be a foreigner.
You're referring to Article 26.
Married to a foreigner, yes.
Yes,
Article 126, Paragraph 2,
Can we just
Your Honor.
put that up so that
Yes.
at least we can be guided accordingly? But you're now changing your
I'm
initial
not-
position when
I'm
you
not changing,
made
I'm-
your submissions before the court.
Yes, I'm just answering one of the questions, whether there is a way to sustain the present petition. And I believe there could be a way, by way of considering the situation as a mixed marriage, because one of the parties acquired a foreign nationality subsequent to the divorce. The question I submitted earlier was that the acquisition of foreign nationality after the divorce does not retroact because Philippine law, following Philippine law, naturalization does not have retroactive effect.
Okay. My understanding previously is
Yes.
that you are for the denial of this petition. So now you're saying that
Yes, Your
it
Honor.
can be granted?
Yes, Your Honor.
Okay.
However, on further reflection, I thought of a possibility of giving retroactive effect to this foreign element by way of a fulfillment of a suspensive condition. I was wondering, why did the foreign court, knowing that the two parties are both Filipinos, why did the California court grant
Agree.
the divorce? It must have been under the concept of a suspensive condition because I think at that time there was already a petition for naturalization by the petitioner. So the judge must have thought that there is a possibility of a mixed marriage, and therefore the nationality principle of Philippine law will not apply. The exception would apply if there is a mixed marriage. And I see it as a special situation, factual situation, where the validity of the divorce was made dependent on the fulfillment of a suspensive condition, which is the acquisition of foreign nationality by one of the parties.
Okay.
And that condition actually happened. And under civil law, the fulfillment of a suspensive condition retroacts. So there is a retroactive effect that would validate the divorce.
Okay.
That is just by way of a possible solution, as the court is asking one of the questions. Is there a way, a possible solution to this situation? This will not make this will not change the nationality principle under Article 15 of the Civil Code. We still follow nationality principle while applying an exception by considering the situation as a mixed marriage,
Okay.
not a marriage between Filipinos.
Okay.
Your Honor.
But Justice, looking at the provisions of Article 26, Paragraph 2, as well as Article 15 on the nationality principle, those conditions that you mentioned cannot be found there.
Yes, Your Honor.
Okay.
Article 15 is the rule. An article of the Civil Code is the rule establishing our basic foundational principle, nationality principle. But we provided for an exception in under 1 Timothy 6, paragraph 2, because the nationality is mixed. There is a foreign element introduced by the citizenship of one of the parties.
Okay. But here we're talking about two Filipinos, one of them obtaining a divorce, and they were not nationals of any foreign country at the time that the decree was granted. You agree?
I agree, Your
Okay.
Honor. They were both Filipinos at the time of the divorce.
Okay. I think
However, I'm positing the possibility that there might be a suspensive condition that will alter the citizenship of the parties at the time of the divorce by a retroactive effect of the fulfillment of a suspensive condition.
Okay. Well, based on my recollection, your position then was anchored on the application of both Article 26.2 and Article 15 of the Civil Code. Anyway, and then one of the things that you mentioned also is that there is a prohibition against divorce here in the Philippines. Do you still maintain that? That there is a prohibition against divorce here in this country?
Yes, Your Honor. The public policy remains that absolute divorce between Filipinos is prohibited.
So, and likewise, as far as you are concerned, the subsequent naturalization as an American and then later the reacquisition of Philippine citizenship or dual citizenship by the petitioner here does not cure the defect of a void decree, a divorce decree that was obtained in October of 2010. Is this still your position?
I submit, Your Honor, that that is debatable whether or not it cures, because if you consider this as an implied suspensive condition that was fulfilled, then it will cure by altering the citizenship of the petitioner at the time of the divorce.
Okay. One more point, Justice. You only cited or invoked Rule 108 for purposes of filing a petition for recognition of a foreign judgment. Why did you not consider Rule 39 as well, insofar as attaining this particular, of course, objective of having a foreign judgment of divorce recognized in the Philippines? You're focusing only on Rule 108 in your submissions. Why is this so?
Yes, Your Honor. I just submit that that's one of the possible way of sustaining this petition, Your Honor.
Okay. I'm grateful for your answers, Justice. Maraming salamat po. Thank you po.
Thank you, Your Honor.
May I ask for Professor Beth Pangalangan to the podium, to approach the podium. I have to disclose, ma'am, that my daughter, Ariane, used to be your student in, not in private international law, but I think in persons and family relations, and which is right down your alley, I suppose.
Your Honor, and I hope she did well.
Thank you, Your Honor. That's, Professor Beth, because that is what she told me, and I did not believe it until you just confirmed it today.
Thank
So,
you, Your Honor.
ma'am, it is your position that any broader remedy for the petitioner should come from legislative action and not the judicial expansion or interpretation of Article 26.2 of the Family Code. So why do you say this again, ma'am? Professor Beth?
Your Honor, I believe that one way of addressing the question and the problem or the mischief, I would say, of limping marriages is through a change in the law. But at the same time, Your Honor, it's still possible for the court, through judicial reinterpretation, to arrive at that same conclusion, Your Honor.
Well, as far as you are concerned, based on one of your submissions, while it is considered harsh, the situation of the petitioner cannot be judicially cured due to the Philippines' continuing prohibition against absolute divorce. Is this still your position?
Your Honor, I have modified that position. In the first place, Your Honor, I did say that the court can, I remember my original memorandum, Your Honor, if that's what you're referring to.
Yes, yes.
Where I said that the court can still decide on this matter, but being careful not to engage into judicial legislation. I think that's what I said, Your Honor.
Okay.
But that it can still be done by the courts.
But you said that it cannot be judicially cured due to the Philippines' continuing prohibition against divorce.
Well, on that, Your Honor, I believe that, because I did some research later on the public policy exception, Your Honor, and then I examined the Hague Conventions, and from these conventions, as I mentioned earlier, Your Honor, the term use was no longer contravention of public policy, but that it is manifestly incompatible. In that way, Your Honor, if manifest incompatibility is required, then I would say, Your Honor, that Philippine law, or the absence of a law on divorce, will not manifestly contravene the public policy, Your Honor.
Okay. You're right in saying that there is actually no law that prohibits divorce.
Yes, Your Honor.
But we know that the kind of divorce that is being contemplated on, among others, that at least by our standards right now, is the kind of marriage dissolution wherein the parties do not even have to come up with any reason, no rhyme, no reason, like what the petitioner Melvin Baluyot obtained in the U.S., wherein it was a default or uncontested divorce that he was able to obtain. Do you agree that this is the kind of divorce that even if it's not in any of our laws, is the one that we are trying to prevent?
Yes, Your Honor. Your Honor, I make a distinction between a divorce law that could be passed in the Philippines. I believe, Your Honor, that if we do have a divorce law, that should provide for specific grounds for divorce, and not just leave it to incompatibility, let's say, of the parties, or no-fault divorce, which we see in many Western countries. So I believe, Your Honor, that even in the discussions of the Constitutional Commission, when Commissioner Gascon was asked whether the present or the way that that Article 15 of the Constitution was being worded meant that the legislature cannot pass a divorce law, he said that no, it's not. It will not prohibit that, and all that he was focusing on was the defense of the family. So I don't believe, Your Honor, that there is an absolute prohibition against divorce, and that the public policy that we refer to is just a limiting device, not a blocking device. So it may be allowed, it may be, there might be a law on that in the Philippines, but under specific grounds, not too liberal. But, Your Honor, if I may, when it comes to recognition of foreign divorce, I think, Your Honor, that's a totally different thing. That the only requirement there is that it is validly obtained abroad. And so for as long as the court that rendered the foreign divorce decree was a court of competent jurisdiction, that it acquired jurisdiction over the party, let's say that the petitioner was bona fide domiciliary of that state, then that decision should be recognized in the Philippines, Your Honor.
Do you agree with the position taken regarding limping marriages, that this is actually addressed, and this is being addressed through the recognition of foreign judgments that we presently have right now?
Yes, Your Honor. In fact, there are several decisions by the Supreme Court where the court would often say that Article 26, paragraph 2 is there to correct the absurd, or to put an end to the absurd situation of a foreigner no longer being married to the Filipino, but the Filipino still being married to the foreigner. And then the court grants the recognition of the foreign divorce or remands the case to the lower court for proof of foreign law.
Okay.
So it's being done, Your Honor.
Okay, but we're only addressing limping marriages involving mixed marriages, no? Involving a foreigner and a Filipino.
Yes, Your
but
Honor.
not a limping marriage involving Filipinos alone. Am I correct?
That's right, with the present
At
decisions,
present, yes.
Your Honor. Yes, Your Honor.
Finally, just to pursue your suggestion that we should not engage, the court should not engage in judicial legislation, and if at all, Congress should address perhaps the provisions of the Family Code, particularly Article 26, Paragraph 2, and even Article 15 of the Civil Code. Can you just briefly tell us what kind of you think amendments should be done to these two particular articles that would, in a way, address the kind of situation that we're facing right now?
Your Honor, thank you. So, Your Honor, I believe that it's no longer on the screen, Your Honor, but earlier
Can we just show the
you put
two?
Article 15,
Yes,
which
yes.
says that the nationality principle will apply to all issues pertaining to family rights and duty, status, conditions,
Yes.
and legal capacity.
Yeah.
So
it's
Your
there.
Honor, in fact, there it is.
Yes.
Thank you, Your Honor. Well,
I
in
hope
fact,
you don't mind, just briefly, what are those you think should help by way of amendment,
if
these
it is-
particular provisions?
if it is the legislature, Your
Yes,
Honor,
yeah, of course. Not the court.
Your Honor, in Article 15, I would make it clear that in cases where the person is a dual citizen, then the application of either the nationality of either of these two nationalities would be sufficient, Your Honor.
Regardless as to when the decree of divorce was obtained?
Yes, Your Honor.
Okay, how about Article 15?
That's Article 15, Your
Okay.
Honor. And
Article
for Article
26.
26.2, Your Honor, as I'm not a fan of this article, Your Honor,
Okay.
so I would remove altogether the obtained abroad by the alien spouse. And in fact, Your Honor, if I may,
Yes.
I would, as I mentioned earlier, Your Honor, that I believe that it is not the nationality of the parties which should determine whether or not the foreign divorce should be recognized. I would keep to the requirement that it be validly obtained abroad, or that the foreign divorce is validly obtained abroad. But, Your Honor, I would remove the requirement that one is a Filipino and one is a foreigner, or I would, Your Honor, allow that not at the time of the marriage, not at the time of the divorce, but at the time of recognition.
Okay, thank you. Maraming salamat po.
Thank you, Your Honor.
May I ask for Dean Mel Santa Maria, please, just for a few questions. So it is your firm position that the petition should be granted, is it not?
Absolutely, Your Honor, yes.
And then to you, Article 26(2) should not be read restrictively since there is no express provision in the Constitution, in our laws, prohibiting divorce, is it not?
Not only that, Your Honor, I consider Article 26(2) as it has become supererogatory, Your Honor. It has been redundant because of Rule 39, Section 48, which has been constitutionalized and is now in the level of a statute.
Okay. So you're saying even when there is no specific law that actually recognizes or allows in the Philippines divorce, And we still recognize this through the, of course, the process of recognition of foreign judgment. So we can proceed to act on this particular petition, despite the fact that there is no particular or express provision as well on the other side, allowing that Filipinos who obtain the divorce decree abroad can have that decree recognized here.
Yes, Your Honor, absolutely. So when we look at the architecture, Your Honor, of Rule 39, Section 48, we look at the reference, Your Honor, is the
It's there.
effect of a judgment. We do not look at the merits of the judgment. We look at the effect of the judgment. And the effect of the judgment comes from a fact. That fact is the judgment. And when you look at this Article 48, Your Honor, it repeats itself almost 6 times. Effect of a judgment or final order without any qualification. It does not say except issues on absolute divorce.
Okay.
There is no mention of that. And just one thing, Your Honor, with respect to Rule 48, Your Honor, when you look at the
Section 48, Section 48,
Section 48,
Rule 39.
when you look at the provisions or the grounds to repel the petition,
Yes.
it says repel. It does not say annul. This court cannot say to another court, your judgment is void, because that is an intolerable affectation of superior virtue. That's the language, Your Honor, in
Okay.
conflicts of law. We cannot do that. We could only look at the effects.
Okay.
So are the effects consistent with Philippine law? That's the only issue,
Okay.
Your Honor.
I ask again, is this court being asked to indirectly look into the issue on the legality of divorce then in the Philippines?
Not so, Your Honor, because creating policy is legislative, but identifying policy is judicial, Your Honor. And we have read that in so many decisions of the Supreme Court.
Okay.
As early as 1939 to 1950s, that in the absence of any constitutional prohibition or statutory provision, the court can identify public policy, whether it is injurious to our society. As a matter of fact, Your Honor, in Fujiki versus Marinay, the Supreme Court said, what then is against public policy? And categorically it says, if it is noxious to our constitutional value. At least that is the only articulation I've seen where it defines what is against public policy.
Okay. It is also your position that denying recognition of such divorces, obtained from abroad by married Filipino couples, especially where one spouse subsequently acquires foreign citizenship, results in inequity and discrimination. Do you confirm that?
That is correct, Your Honor. If you look at this from the perspective of Article 26(2) and our policy today on disallowing recognition, our policy today, Your Honor, I'm sorry to say, borders on racism, is xenocentric, and it mirrors a colonial mentality where the natives have less rights, and if they want to have more rights, they have to associate themselves with a foreigner.
Okay.
It is so deleterious to our culture and our tradition, Your Honor. This is discriminatory. Nothing is more obnoxious than that, Your Honor.
Okay. So in this particular case, who, per your assessment, is considered unequally treated or discriminated against? Is it the petitioner or the wife?
Your Honor, we are talking, this is a case of equal protection that does not involve a particular set of waiters or a particular set of police or a particular set of policemen. This is the Filipino nation, Your Honor. This is the Filipino nation, Your Honor, so that the right comparator is Filipinos with privilege and Filipinos with no privilege. Why do you distinguish? Why is it, Your Honor, that the only magic for recognizing a marriage is the presence of a foreigner? That is,
Okay.
that is That is unpatriotic, Your Honor.
So I get it to mean that to you, both parties can be considered as having been, or can be considered as being the subject of inequity or discrimination.
Precisely because by the policy we have now,
Okay.
if two Filipinos files a case in the Philippines for petition for recognition of foreign judgment, siguradong talo, Your Honor. Automatic rejection. Hindi man lamang titignan.
Okay. If the petition is denied, what do you think is the remedy of the petitioner to have his divorce from Maria Fe recognized so that he could remarry under Philippine laws?
Well, if this petition is denied, I'm sorry for them. They were just the victim of discrimination. But what can they do? Probably they just have to live their life in the United States and not live here, because our policy now is a disincentive to our citizenship, to being Filipinos, Your Honor. Imagine, Your Honor, this case. Kung ako lumiligaw sa isang babae at kanu ako at ang karibal ko Pilipino, sasabihin ko sa babae, ako pakasalan mo sapagat bibigyan kita ng karapatan na hindi niya mabibigay. Ang bibigay kong karapatan sa iyo, madi-divorce mo ako. Siya hindi.
Okay.
So therefore, Your Honor, it's a disincentive to being a Filipino. So I'll tell them, umalis na lang kayo.
Okay. You give too much premium regarding Section 48 of Rule 39.
Yes, Your Honor.
But insofar as the recognition of foreign judgments, and then with respect to limping marriages, but still this particular rule cannot be isolated in the meantime with Article 26.2. Am I correct?
Your Honor, it can be, because this is the very special function, an extraordinary remedy provided in the rules of court to be able to base your cause of action from a foreign law, ventilate it in a foreign judgment, and recognize that judgment as a fact in the Philippines. We do not deal with the merits. We just say, ano ba nangyari sa'yo? Single ka na ba? Okay, let's see kung ano ang karapatan ng single sa Pilipinas at single doon. Tumutugma ba? O wala naman palang problema eh. Let's do it. That's the point of Rule 39.
Just a final point. Yes, just a final point. You're saying this can stand alone in relation to the recognition of a foreign judgment of divorce?
Absolutely, Your Honor.
Section 48, Rule 39?
Absolutely, Your Honor, because it has been constitutionalized by Mijares versus Ranyada. It has become generally accepted principles of international law, and our Constitution provides that we adopt the general principles of international law, Your Honor.
Thank you very much, Dean. Your answers are well appreciated.
Thank you, Your
Can
Honor.
I ask for Dean Lopez Rosario, please, to proceed to the podium for some questions. Dean,
Yes,
it
Your
is
Honor.
good afternoon.
Good afternoon.
Dean, it is your position that the case should be remanded instead.
Yes, I don't think that the petition should be granted, especially that I've heard earlier that the reason why petitioner is seeking for the granting of the judicial declaration, number one, for the acquisition of property, and the judicial recognition of the decree of divorce has nothing to do with acquisition of property. Second, he also mentioned about the religious ratification. As a matter of fact, if this petition will be granted, in my humble opinion, Your Honor, the validity of the second marriage will be at risk. To grant a retroactive application will be unfavorable to the first wife, because we're not only talking about the status. Remember that, number one, judicial recognition of decree of divorce is granted under Article 26, Paragraph 2, to allow a Filipino spouse to contract marriage. in our case here, there was already a second marriage that was celebrated. So what's the purpose of granting the petition for judicial recognition?
Okay. If it is remanded, will this not cause further delay insofar as what is being sought by the petitioner?
My suggestion there is for the petitioner to prove, because in my opinion, what is vital is, although the second marriage was contracted when he was still a Filipino national, but after getting married, he acquired an American nationality. And that's the reason why in the certificate that he is an American national, I myself, when I saw the attachment, it says he is married. So the question that I want him to raise in the lower court is whether his acquisition of the American nationality recognized the decree of divorce that he obtained when he was still a Filipino national. So, in other words, when he became an American national, this is where we follow now the nationality theory. If American law recognized the decree of divorce that he obtained while he was still a Filipino national,
Okay.
then we have no question about it. We just simply have to respect it.
Still, if this case is remanded, the parties will have to reckon with Article 26.2. Is that correct?
Again, going back to the purpose of petitioner, the judicial declaration of the decree of divorce has nothing to do with the acquisition of property. Second, as I've said, granting that petition will expose to risk the validity of the second marriage.
Okay. To you, the text at present of Article 26.2 creates unequal treatment between Filipinos in mixed marriages and those who later acquire foreign citizenship, effectively leaving them in legal limbo. So are you saying then that Filipino married couples who can afford it, should be allowed to get a divorce abroad instead of having their marriages in circumstances permitted here by the family code, annulled or declared annulity?
Your Honor, I still take into consideration the rationale behind the insertion of the second paragraph of Article 26. That is simply to address the problem of Filipinos married to a foreigner, okay, who under the national law of the foreigner, divorce is allowed. Now, with the ruling of this High Court in the case of Manalo, we respect that, although it also involves a union between a Filipino national and a foreigner.
Okay. You claim that a judicial recognition of a foreign divorce in the Philippines can be obtained through either Rule 108 or Rule 39. So
Yes,
based
Your
on your
Honor.
assessment, which is the rule that expedites such judicial recognition proceedings? A special proceedings case under Rule 108 or a ordinary civil action under Rule 39?
In my opinion, I think it's Rule 108.
Okay. Rule 108.
Yes, Your Honor.
So you do not join Dean Mel insofar as the
With due respect to him, Your Honor. But it's just
premium position
my
of
opinion,
Rule
yes.
39. It is your position that a foreign divorce produces legal effects in the Philippines only upon judicial recognition. So does that mean that the marriage of petitioner Melvin Baluyot and Maria Fe, without judicial recognition at present, is still subsisting even now under Philippine laws?
Under Philippine laws, yes, Your Honor. But then, if it can be proven, that's the reason why my recommendation is, if ever there was recognition when petitioner acquired American nationality regarding the decree of divorce that petitioner obtained when he was still a Filipino, then applying the nationality theory at the time, then we have to respect it.
Okay.
The problem is, under the Dual Citizenship Act, there is no mention what will be the effect if ever there is a conflict between the civil law of two countries where the person involved has nationality. And I think that's one of the things that, with your recommendation, the legislative branch of the government can look into.
Okay. So, since there is no judicial recognition and the petitioner decided to remarry even before that recognition, and if we agree that Philippine laws still apply to him, then that particular second marriage can be questioned. Is it not?
No, Your Honor, as I've said, if the his nationality as American citizen recognized the decree of divorce that he obtained, even when he was still a Filipino national. And I think it was reflected in his certificate of an American citizenship because it says there he is married. Then we have to respect that because up to now, he is an American national. And I think we also have to take into consideration the domiciliary theory. Petitioner does not reside here in the Philippines. Petitioner resides in the States. So if his American law recognizes it, then who are we to question it?
That's American law. But Philippine law, if it is applied?
If it is applied, I think, as I've said, there is a risk because it will be untimely to grant the petition for judicial recognition, considering that there was already a second marriage that was contracted. We have to take into consideration that declaration or judicial recognition of the decree of divorce is only granted to give the Filipino spouse the opportunity to contract a second marriage. But the situation of petitioner is different. The marriage is already contracted. So in my opinion, Your Honor, to give a retroactive application will be unfair to the Filipino spouse, the respondent. Because we're not only talking here of the status, it also involves the property relationship. And we know that under Philippine law, any property acquired during a valid marriage should still form part of the conjugal partnership or absolute community in the first marriage. That's the reason why, if ever petitioner can really prove that his American citizenship recognized the decree of divorce, then we have to respect it.
Okay. Thank you, Dean, for your confirmations and your answers.
Thank you,
Finally,
sir.
Solicitor General Berberabi, please.
Good afternoon, Your Honor.
On a personal note, you were our former frat sweetheart in the UP College of Law. So I will be gentle and kind. I'm just kidding. I'll just ask you some questions. Well, Petitioner Melvin Abaluyot would like the court to grant his petition by letting us agree to his proposition that Filipino married couples may be allowed to obtain a foreign divorce decree, then acquire via naturalization the citizenship of another country, like the U.S. citizenship that he was able to obtain, then later on become a dual citizen pursuant to RA 9225, and thereafter file a petition for the recognition of foreign judgment that the trial court should favor. So the state has taken a different position. Why again are you opposing this particular petition?
Okay, thank you, Your Honor. It is the position of the Republic that the Article 26, Paragraph 2 is very clear, also supported by the, so first is the text, and second, supported by the deliberations. And what happened that the exception was just inserted by executive fiat, and it is because in the committee that deliberated on the family code, there was a tight voting, 5-4, and therefore it was so problematic that they decided that it will not be part of the family code, but subsequently, President Aquino, by executive fiat, inserted it.
Okay.
And therefore, it is the position of the Republic that it is referring only to a very narrow exception. And the jurisprudence has stated time and again as to the requirements when Article 26, Paragraph 2 will be applicable. And the first requirement is that it is a mixed marriage between a Filipino and an alien, and which does not obtain in this case. Second, it is also it is the position of the Republic that absolute divorce is against public policy by and it is supported by the history of divorce being present in our previous laws, but deliberately omitted in the family code, in the new civil code as well. And therefore, what our laws, the Constitution, and the statutes allow is just relative divorce and not absolute divorce. So it is the position of the Republic that since the discussion itself goes to the heart of this issue, the issue is whether the statutes could allow for a divorce between two Filipinos. That was actually the question.
Okay.
And its inclusion in the family code was upon the premise that it should not be allowed for two Filipinos, but only in this narrow exception. And being an exception, based on statutory construction rules, it should be strictly construed, Your Honor.
So completely, Filipino married couples cannot go abroad, obtain a divorce of decree, and then come to the Philippines and have that recognized.
That is correct, Your Honor.
Okay. It took petitioner Melvin Baluyot more than 10 years, as I mentioned earlier, after getting the divorce decree in October 2010, before he filed his petition. What can you say to this long period of time that it took him to do so?
I do not want to endeavor, Your Honor.
Should that be taken against him?
Well, it is the position of the Republic, Your Honor, that the factual disclosures in the last compliance are supportive of the position that perhaps there could be some steps that were taken to circumvent the laws of the Philippines, and which is also one of the things that has been warned against a backdoor system that might be taken advantage of Filipinos who are who have the resources to go abroad and obtain divorce.
Okay. Do you think should there be a period under the rules for those who would like to be covered by Article 26.2 and the rules, on the recognition of judgment, so that this, prolonged period of time to file it can be addressed?
Your Honor, I remember reading also the deliberations in the family code, and there was also a point where a period of time was being suggested, but the framers, the committee then decided not to include any period of time because perhaps of different circumstances that might get into the situation or scenario.
The principle of unclean hands, you mentioned that as well as one of the reasons why the Republic is opposing this particular petition. So, at what point were these unclean hands manifested by the petitioner so much so that he should be made accountable for that?
Your Honor, It wasn't disclosed in the first place that it has already invoked the power of the judiciary, that there has been a decision with regard to its petition for declaration of nullity. I would also like to correct, based on the compliance, the statement of the counsel for petitioner. The basis for the petition for declaration of nullity is based on no authority of the solemnizing officer and not, I think, psychological incapacity. So that fact, and that it has already entered into a second marriage, those two were subsequent disclosures, Your Honor.
How about after obtaining a decree of divorce, he eventually acquired U.S. citizenship, and then only after obtaining or acquiring U.S. citizenship that he decided to file the petition?
Yes, Your Honor, there is an opening to argue that it could have been done in order to have standing in Philippine courts.
Because that would make him at least supposedly covered under Article 26.2, is it not?
I agree, Your Honor.
Okay. By the way, has your office done any research on the law of the state of California, which grants a foreign national, like the petitioner, who was a Filipino when he sought relief, and whose marriage was not solemnized in the U.S., the right to seek a divorce that is binding not only in the U.S., but which can be the subject of recognition here in the Philippines?
No, Your Honor, we have not.
No. I ask again, if the court decides to grant the petition, despite the clear text of Article 26.2 of the Family Code, which covers mixed couples, as you mentioned, do you consider this as judicial legislation, if we grant?
It is my respectful submission, Your Honor, that it will be because of the specific point that I mentioned a while ago, that this very point was considered by the framers of the Family Code, and which also give us a flavor of what was their specific intent.
Okay.
So the text of the law is clear, and the intent is also very telling, Your Honor.
Okay. If the court grants the petition, will this not benefit other married Filipino couples who are similarly situated like the petitioner and Maria Fe? So is this going to be in accordance with the state's constitutional duty to protect the sanctity of marriage as an inviolable social institution and the foundation of the family?
Your Honor, that is a very difficult question. However, it is the submission of the Republic that when the Constitution says that marriage is an inviolable social institution, it means that our laws and our Constitution would provide for the mechanisms, provide for the requirements that will determine what are the requirements for marriage, when can the spouses exit the marriage. So it is our humble submission that the inviolability can have different levels of protection. And what the Constitution protects is the institutional protection. And the reason why the Supreme Court is confronted with many cases is because if you protect marriage from an institutional perspective, being confronted with specific cases might also confront us with the outcomes and results. And it is our position that if the law is clear, then we determine the decision or a judgment based on the law and do not decide based on outcomes in the first place.
Okay. May a law be passed that will retroactively apply to Petitioner Melvin Baluyot, recognizing that divorce decrees obtained in foreign countries by married Filipino couples may be recognized in the Philippines.
Your Honor, may I clarify, is it your question that if there will be a law?
May a law be passed? Can a law be passed that will have retroactive effect that will address the situation of the petitioner here, that even if the decree of divorce was obtained at the time that they were both Filipinos, that this can be recognized in the Philippines?
I believe, no, Your Honor. It will also have a lot of complexities with regard to the children, for example, of the first marriage and the second marriage. So, going by the ruling of the Supreme Court in Tan versus Crisologo, which we could, although it was referring to political rights under 9225, I think that the laws or the application should be prospective, Your Honor.
Okay. As a final point, if the petition is denied, and then assuming that he goes to another territorial jurisdiction and obtains another decree of divorce and comes back to the Philippines to have that recognized, can that be blocked? Can that be prevented by the state? And on what ground?
I haven't thought through it thoroughly, Your Honor, but I would think, because I was also checking as to what is the solution, and I am inclined to say that that is possible, Your Honor.
Okay. Maraming salamat, Solgen Lelen, sa mga sagot at nagbigay liwanag sa mga katanungan ko.
Thank you very much.
I am done already, Mr. Chief Justice, with my interpellation. Salamat po.
Thank you, Justice Raul. So as not to interrupt the flow of interpellation, we will adjourn today and resume on July 14 at 2:14 p.m. 2 p.m. Thank you. Clerk of Court, are there any other matters?
There are no other matters, Your Honor.
Okay, the session is adjourned.